I'll call to order this June 19, 2020 continuance of the Seattle Waterfront LID assessment hearing. Today is planned as a continuance to hear the presentation of the city's case. Just as a reminder, only the city and objectors planning to cross-examine the city's witnesses will participate directly in the hearing, as provided in several pre-hearing orders that have been issued. Other objectors and the public may listen to the hearing via listening line, access to which is identified on the Hearing Examiner, Office of Hearing Examiner website, front page, under the hearing schedule. That website is www.seattle.gov/hearing/examiner. Callers will be able to listen in the hearing, but not participants for any purpose. In addition, the Seattle channel will continue broadcasting today as they did yesterday. Yesterday's hearing has already been posted to their website and should be, may even be within a link to the hearing examiner's website already, as all of those were provided by the same link. And so yesterday's hearing is already up. Reminder that the hearing should be treated as an in-person hearing. Although people get casual in their homes and offices, this is still a quasi-judicial forum. Please treat each other and the forum with that due respect. The schedule will follow as with yesterday. We'll take a 15-minute break at 10 a.m. We'll take lunch at noon until 1:15 p.m. And then we'll take another 15-minute break at 3 p.m. We had reasonable success with the hearing progress yesterday, and hopefully that will continue. However, if in the determination of the hearing examiner the technology supporting the hearing is not performing adequately, the examiner will suspend or continue the hearing or a portion thereof, make arrangements for submission of materials or testimony later, or make other necessary arrangements. Reminder of our protocols for participating during a recorded hearing. It is recorded, so make sure that there's only one individual speaking at a time. Participants not actively presenting testimony or argument should mute their microphones and shut off their video feed. Every effort should be made to isolate yourself from background noises in the home or office. Please make sure your cell phones are off. If you're participating directly, make sure that your eyes remain on the video screen. It helps in part to make sure it's clear that you are actually speaking to the examiner and that I'm receiving your testimony. It also helps to make sure that if you are not being heard on my end or by another participant who comes in and says they can't hear, that there can be a signal raised. We raise a hand indicating that there's no signal the audio is not being received, and stop speaking until it's reconnected. But that can only happen if you keep your eyes on the screen. Anyone who's not proceeding with the protocols will be muted and or possibly removed from the hearing. If you have any technical or general procedural questions that do not require my immediate attention, please use the chat for addressing those to the legal assistant. Do not use the chat feature for any other purpose. It is not there for participants to carry on side discussions. But if you have a question about access to a exhibit, or if your connectivity is not working, alert us to that and we can try to address it if you do that by chat. Is there anyone, I stated this yesterday, how we're proceeding with objections, meaning procedural objections, not the objection you filed as a basis for your appeal, but a procedural objection. Is there any question from any of the objectors on how we're proceeding with how to handle those? I can repeat what I read yesterday, or we can move on. If I don't hear anybody asking for a repeat, I will move on from the description of how we're handling objections. Are there any questions about how to approach objections? All right then. The only thing remaining then that I have is a note on addressing exhibits. While the Office of Hearing Examiner does not normally handle exhibit exchange, under these circumstances, we are attempting to try to make sure that parties have received the exhibits from the city. And we had a list of some individuals at the end of the hearing yesterday that indicated they were not able to open or had not received some exhibits. Hopefully that was addressed at the end of the day yesterday. I know we heard from some of you. Is there anyone remaining that has not been able to open or access exhibits sent by the city?
This is Judy Donnelly from the Women's University Club. I am not able to open up C13, C18, C19, and C22.
Okay, thank you. What we'll do is if any of those are being referenced, I'll ask that Mr. Filippini for exhibits 13, 18, and 18, 19, and 22, if you reference those in upcoming examination of your witness, please share screen for 13, 18, 19, and 22 so all participants can see them as part of the hearing, although I think we've been through several of those. Some of them are larger documents, and I think that may be why connectivity is difficult for some participants. Is there anyone else that has any difficulty in accessing, opening, or having received exhibits?
It's Todd Reuter, Your Honor. I received the exhibits, but I have a question about how we should be numbering our own exhibits when we begin our cross-examination. Should I raise that now?
Well, I'll tell you what I said yesterday, and that may not have addressed all your questions, but I'll just tell you what we got so far. Is the intent is that this is the city's portion of the case, and so when we get to cross-examination, there's two ways that I've identified for how you should handle exhibits. One, if possible, if you're using an exhibit that's already in the record, either from your own case or another, you should be referencing it by case number and exhibit number. So for example, if you have under your cases, they should have all been consolidated for years. I don't think we had separate exhibit numbers assigned for each of the case numbers that you're representing. But regardless, under each case number, there is a list of exhibits that were submitted for those. And so those are static exhibit numbers that if it's possible to reference back to those, it's appreciated because so we don't get redundancy in the record. Recognizing it's not possible for everyone to go back and reference everybody else's case numbers and exhibit numbers, there's going to be some redundancy. For new exhibits coming in that you're not able to cross-reference back to existing numbers, I've asked that we continue with the city numbering system. So we will be leaving off with however far the city gets us today. Let's say they get us up to exhibit 28, we'll pick up with exhibit 29 starting on Tuesday, and we'll be proceeding in that manner.
Okay, and so the city is using a prefix that begins with the letter C. Should our next exhibit then be C29?
I think you can. I guess let's. I've given you some guidance on it, but I think that there's probably going to be some challenge in you all coordinating what your exhibits that you're submitting and how you're planning to do that for next week. And I do plan on at the end of today having a discussion about next week. And so what I'd like to do is, instead of just trying to address this with you, but other objectors may also have questions about this. And I'd like to hear from objectors how you plan to submit an exhibit. So for example, if you head in the direction of doing C29 and 5 other people do the same thing, that's not gonna help anybody. So rather than trying to address that now, let's try to do that at the end of the day.
Thank you.
Yes. Any other questions about access to city exhibits for the hearing today? All right. Any other procedural issues or questions before we continue with the city's presentation? All right. Then we turn back to the city. Mr. McCullough, you remain under oath or affirmation from yesterday. Mr. Filippini, it's your witness.
Thank you. Mr. McCauley, we left off yesterday at the bottom of page 3 of Exhibit C21. If you could get back to page 3 of C21, please.
Yes, I'm there.
Okay. And I've got, we were talking about paragraph 3A, and I have a question for you. I'm going to read to you. There's a, following the bullet points, there's a standalone paragraph that begins with the word beyond. And in that sentence, notes that, quote, the very nature of the public improvement, a regional park, and the wide LID boundaries described in the report suggest that the entire project could be described as offering almost entirely general benefit, end quote. What is your response to this observation?
Well, I just don't agree with that comment. All of the other similar projects, the comparable projects that we analyzed as part of our work clearly showed that there was special benefit increases in market value that were occurring as a result of projects that had similar elements as what the Seattle Waterfront project consists of. So I disagree with that comment.
And what's the connection, if any, between the size of the LID boundary and whether or not it generates special or general benefits?
There is none.
And then that paragraph, same paragraph, Bob, on page 3 of Exhibit C21, concludes with an observation about the total value of the real estate within the LID boundary. Does the $48.1 billion of total real estate valuation, where does that come from?
That's the total amount of all of the real estate within our study.
Okay. And what connection does the total valuation of the real estate in an LID have to whether the benefit provided is special or general?
None.
And why is that?
The size of the boundary, and oftentimes when we're doing LIDs, we have rather large boundaries, oftentimes small boundaries. It's just not relevant from our analysis standpoint.
And then the next sentence, this is the final sentence of that same paragraph on page 3 of Exhibit 21, notes that you used the word generally to discuss benefits at points in your study. What did you mean when you used the word generally?
Just as a figure of speech, it had nothing to do with general benefit.
I'm going to take you to the next subsection entitled Method of Assessment. In here, Mr. Gibbons asserts that in order to assess benefit provided by the lid improvements, that you applied a percentage to a concluded before value. So my first question to you, Bob, is how did you assess the special benefit provided?
Yeah, so the special benefit was done on a parcel by parcel basis, estimating the market value without the LID and as at the same date and time with the LID to derive the special benefit amount.
Okay, and did you apply, quote, a percentage to a concluded before value?
No, that's absolutely false. The percentage that was shown was just the relationship of the special benefit to the before value to show what that percentage change was. And again, that was used for informational purposes for proportionality.
If you look at the bottom of the page, again, same page 3, C21, there's an underlined text that reads, as the value, quote, as the value lift should be calculated, not applied. And what is your reaction to the underlined text?
Well, again, we did not apply a percentage change to calculate our benefits. So that statement just is not factual to what we did.
And did you calculate the value lift for each parcel?
Well, the special benefit is the market value difference between the properties, and that's what the property, and that's what we estimated.
On a parcel by parcel basis?
Correct.
And from testified yesterday you were familiar with Mr. Gibbons' testimony in the hearing when we first looked at Exhibit C21. What is your understanding as to why Mr. Gibbons apparently believes you did not calculate, but rather apply the increase in value?
Yeah, I have no idea. Maybe he didn't read the report. I've known Mr. Gibbons for many years. He simply could have given me a call and asked me questions relative to a lot of issues in this document.
So let's look at the next subsection C, which is entitled, it's on the next page, page 4 of Exhibit C21. And it's entitled Before and After Description. And I'll read you the first sentence and then ask you a question. Quote, there is very little clarity in the appraisal as to the precise value difference arising as a consequence of a comparison of the before and after. Again, what is your response?
Well, again, individual worksheets were done for each property. To me, that provides a lot of clarity. There's a spreadsheet that shows our market values before and after. Again, I think it's clearly spelled out in the report, the process that we undertook. So I just don't agree with that comment.
How does your study address the removal of the Alaskan Way Viaduct?
Both in the before and after, we recognize that the viaduct would not be in place anymore, and those elements that of view and whatnot were not affected by the market.
And how does your study address the rebuild of Alaskan Way and other changes that would occur without the LID?
That's a hypothetical condition that we're considering in the before condition that it would be in place.
And do you value those changes in the before condition that would be in place without the LID?
Correct.
How did you address parking in the final benefit study?
Parking was looked at both in the before and after condition, and there was some parking loss in the after condition, and that was done on a parcel by parcel basis. To some degree, it was offset by the increase in pedestrian traffic that is probable to occur as a result of the project. But we did consider it in the reconciliation process of estimating benefits for the properties that we felt would be impacted by it. And those were primarily the waterfront properties.
And how would a reader of your study know that you addressed parking in your study as you just described?
It wasn't real clear in our study. We didn't do we mentioned it, but we didn't do a separate parking study or anything of that nature. So it could have been spelled out more clearer in the report than what we did, but it certainly was addressed and recognized in the report and in our analysis.
I'm going to ask you to turn the page to page 5. So Exhibit C21, page 5. And there's a subheading 2 labeled cost. Let me know when you're there, Bob.
Yes.
So what relevance does the cost of the LID improvements have in your analysis?
In this instance, it's really more or less irrelevant. In a lot of LIDs you'll be doing, if it's say a road improvement LID where a mitigation requirement of development would be to build half street improvements or side curb gutter sidewalks, and the LIDs accomplishing that as a part of the project. Costs then become more involved in your analysis because it's really relative to buyers and sellers in the market to what additional costs they would need to do when buying or selling a property. In this instance, just given the vast magnitude of the LID, I mean, no one property owner could afford to pay $346 million to accomplish what's going on. So it really wasn't relevant from an analysis standpoint.
And what's the relationship between special benefit provided by improvements and cost when you're doing a special benefit and the cost of the improvements when you're doing a special benefit study?
Well, as I said, it varies on the type of benefit you're doing. And in this instance, the cost is not something that is of real significant importance to what we're doing.
What if the special benefit provided is less than the cost of the improvement?
Well, that just would be what the market's reflecting.
Okay. Let's talk about in this particular LID, what's the approximate total cost of the 6 improvements funded by the Waterfront LID?
$346 million.
And what's the total special benefit you measured from the Waterfront LID improvements?
It's about 400 and close to 450 million.
Same page, I'm going to take you down to timing, the very next piece. That's on page 5. It's actually, it has the subheading of 1, but it follows cost. But in any event, it's timing toward the middle of page 5. And before I ask you a question, Bob, just read to yourself, please, those few sentences, and then I'll ask you a few questions.
Yes, I'm aware of that.
Okay. So my question is, how did you address when the Waterfront LID improvements would be built in your analysis?
Well, as of October 1st, 2019, we recognize both in the before and after that the improvements are in place.
And is setting a valuation date a standard practice in a special benefits analysis?
Yes.
And how does setting an evaluation date for purposes of a special benefit study compared to, in your experience, other sorts of real estate valuation?
It's relevant in any type of valuation, and the impact of noise and disruption and things of that nature in relation to an LID. It's similar to eminent domain, to where it's in eminent domain that the disruption and the noise is not compensable. So it's not something you consider in your analysis. And it's similar in doing a special benefit study. We assume the project's done, therefore those elements aren't considered in our analysis.
So if the improvements aren't built yet, why not discount? Well, let me ask first, did your study discount the values for the fact that the improvements weren't built yet?
No.
And why not?
Well, we had felt we had real sufficient information of all of the project elements to a reasonable position to where we could make estimates of our before and after values. And we're looking at as of a certain date and time. So the relevance of looking at it down the road just isn't practical from the scope of services that we had.
And if after you made your valuation, something happened in the market to increase values, for example, Amazon builds HQ2 in the town where you're doing your valuation, what effect would that have on your special benefit numbers?
Yeah, it wouldn't change unless the market knew that was coming as of the October 1 date. Then they may consider some elements in their purchase decision of that. Conversely, just as we are now, where the market wouldn't recognize the COVID issue back in October of 1, it just wouldn't be something that wouldn't have been known in the market.
So in both scenarios, would not play into your valuation?
Correct.
What role does anticipated construction activity have in your evaluation process?
Well, I'm not sure what you mean by anticipating construction activity. relative, again, if it's relative to the project, then it has no bearing.
How about, so let me be more specific, noise and dust from the construction of the LID improvements? What effect would those have on your valuation of the LID improvements?
Yeah, again, as I explained, it's not something that we consider. We assume the project's completed, therefore those nuisances are not relevant in our market analysis.
Ask you to look at the next section in the letter labeled D. Still on page 5, Bob, right about in the middle of the page. It's entitled "Assessments Are Not Supported by Empirical Data." Again, if you could read that first paragraph, and I'll actually read a sentence into the record, and then I'll ask you some questions, Bob, but it's contained in the first paragraph. It's the second sentence. Quote, "The appraisal does not provide discrete and empirical before and after analyses of purportedly similar public projects across a wide range of property takes." My first question for you is, what role did empirical data on comparative projects play in your analysis?
We had a significant number of studies we looked at throughout, as I'd mentioned before, throughout the country, in Boston, New York, San Francisco, other areas. At least 25 studies we looked at that provided a very sound, good basis for our before and after conclusions. A lot of the projects, if you looked at their before condition, yet certainly there were significant differences between the before condition. There were also, in the after condition, there were also a lot of similarities to project elements that are being completed by the Waterfront Seattle project.
And in as an appraiser, what's the difference between empirical data and anecdotal evidence?
Well, anecdotal, I mean, we confirm sales all the time. We talk to real estate brokers in the market to get their opinions on buying and selling property, what their thought process was, what their motivations were, to make sure that it's a fair market sale, versus studies that we do in the market.
And do you use both types of evidence in your work?
Definitely, yes.
Okay, and did you use both here?
Yes.
If you could look at the next paragraph, it starts with the word "moreover." Again, page 5, exhibit C21. And I'll direct your attention to another sentence. Again, it's the second sentence. Quote, "Application of a 0.5 to 4% value change on a general mass appraisal basis falls well below the standard of error already present in such an analysis. In effect, the analysis reveals the benefit is immeasurable at this level." So my first question is, what is the standard of error present in a mass appraisal?
There is none. In almost every LID we've done, or I've done over the last 30 years, we often come into a point of our analysis where the special benefit is very, very small. So it's very common to have, in some LIDs, you'll have very, very large benefits greater than this. Other LIDs, typically when you do get to the outer edge of a boundary, the benefits are very, very small. And that's why the boundary stops at that point.
And can you give us an example on this project where you found that the benefits were very small out toward a boundary?
Yeah, well, particularly out towards the Denny Triangle area, moving up towards I-5, you're getting well away from the project, and that was the area we had our smallest level of increase.
Okay, and do you know, if you recall, what was the smallest benefit increase that you found in the project?
I believe it was a 0.05.
And how did you estimate values, in dollar terms or in percentages?
Well, the difference in market value is a dollar figure. The special benefit is a dollar figure. So that's how they're calculated.
And then, so with the underlying before values that you estimated for some of the improved properties in particular, what does explain for us the difference between the dollar value and the percentage that converts to?
Well, again, when we go through our analysis, we arrive at a before value and an after value, and the difference of those two is the special benefit. And the percentage amount that we're showing is just the difference between the before and after values to create a percentage amount that reflects that relationship. It's a result of the analysis. It's not taking the percentage and applying it to something to come up with the benefit. It's just the result of the benefit.
Right. Understood. My question is, when you are doing your study on a dollar basis, as you said, and you have, say, a property worth hundreds of millions of dollars, and you have a $4.5 million increase, and I'm taking this example, actually, I'll direct your attention to the third paragraph under section D on page 5 of C21, where Mr. Gibbons cites a $4,516,000 benefit that you estimated on 1201 3rd Avenue office tower. Comes out to a 0.62 difference. And so why is that?
That was the benefit amount difference that we arrived at, and it reflected a 0.62% difference. And to say that that's remote and speculative, I mean, 4.516 million is a significant figure, and just due to the considerable high value of the property, it reflects a small percentage change.
And so in the work that you do, special benefit work, how common is that for high value properties?
Very common.
I'm going to take you to section E. Begins on the bottom of page 5, but really that's just the header. But it's assessments including percentage assignments. Assessments include percentage assignments to improvement value. But the actual text continues or begins on page 6. What I'd like you to do, Bob, is just take a minute and look through this before I ask you questions.
Yeah.
Okay, and in this section entitled, again, assessments include percentage assignments to improvement value, what do you understand to be Mr. Gibbons' argument?
Yeah, Mr. Gibbons is saying that the benefit should be just in the underlying land.
Okay, and what is your response?
My response is that you need to look at the whole bundle of rights of the property. You need to look at land, and then you also need to look at the whole property as an entity, and the relationship of the increase in land to the relationship of the increase of the whole property. Due to the high density of availability to develop in this market, for instance, a number of the zoning designations have an unlimited height limit. There was a proposed project in front of the Columbia Center a number of years ago that wanted to go up 100 stories, and the only reason that they couldn't was the FAA. It was too high. So that was really the only restriction on height was an FAA requirement. So you need to look at in this kind of density. You need to look at both land value and look at the whole bundle of rights in order to comply with the state statutes and value the fee simple interest of the property. So it's not just flowing down to the land or saying that all the benefits in the land. You need to look at the whole property.
And there's we call it a chart or a table, but there's a box in the center of the page on page 6 of Exhibit C21, where Mr. Gibbons points out a difference in your assessments for the 2+U building at 1201 2nd Avenue, a temporal difference. So a difference between your preliminary special benefit study and your final special benefit study, the valuation of that property. What accounts for that difference?
During the preliminary study, the 2+ use site was under construction. It was partially built. So at that point, we're looking at the market value before and after the improvements as of that date and time. A year plus later, the project was complete. It was fully leased. All the cost and risk and labor and capital of finishing the project was completed. So it was a different appraisal amount and process that we went through from the preliminary to the before. So different benefit estimates were derived at, and that's why you see the difference.
And so when you're valuing vacant land in your study, explain to us what factors go into that.
Yeah, it's really a highest and best use factor. Do the improvements generate income and value over and above land value? So if they do, they may be an example of the highest and best use. If land value is greater than the capitalized value of the existing improvements, then the highest and best use of the site may be for redevelopment.
And then if you could look at the next box there. And this is example of the Cyrene Apartments and the Woldson parking lot. So there's a comparison here between the Cyrene and the Woldson parking lot. What accounts for the differences in those assessments between those properties?
Yeah, again, this is a really good analogy of you're looking at a vacant site that has a proposed apartment project to be placed on it, comparing it to an existing, well-established apartment building that is leased at stabilized occupancy. So you're kind of comparing apples and oranges. The vacant site, the Wolfson site, which is right on Alaska Way at Seneca, that site hasn't had the labor and capital and risk of construction or the 100 million or whatever of capital investment that's going to go into that site hasn't been done as of the date of our value. So comparing that to an existing property that can take advantage of the amenities, the revenue amenities that are going to be generated by the LID, they reflect and should reflect different market value estimates.
And in your professional opinion, would the market value how would the market value the difference between a vacant lot, the Woldson parking lot, and the Cyrene Apartments?
Yeah, the underlying land, and that's why we look at land. The underlying land percentage change or the underlying land change would be very similar, but on an overall basis, the Cyrene properties, because they're in an existing building, would reflect a higher benefit and do reflect a higher benefit than a site like the Wolfson site that has yet to be constructed.
Finally, I'd like you to look at page 7, the last page of Exhibit C21. In the conclusion section, and I'll actually just take you right down to the last sentence. And that says, quote, however, the application of the special benefit methodology to a downtown area for a park amenity represents a challenging and potential impossible assignment if it is to be free from speculation and imagination. And what's your response to that conclusion?
Well, I mean, it certainly was a challenging assignment when you look at all of the different property types and uses that are existing within the LID boundary area. It was a very, very time-consuming and challenging project, but it was completed on a parcel-by-parcel basis. We complied with state statutes. That definitely something that's not speculative or remote or anything. It was done, and we accomplished it.
So turning away from the report, or I should say my next questions for you don't come from this document. Mr. Gibbons also testified about the effects of COVID-19 on the continued relevance of the final benefit study. Are you familiar with that testimony?
Yes.
In your professional opinion, does the COVID-19 conditions, the pandemic, make the final benefit study obsolete?
No.
Why?
Markets often go through fluctuations. If you even go back to people that bought property back in 2006 and 7, they wouldn't have remotely thought that this recession was going to happen in 2010. Since then, obviously, the market recovered, and people that invested property in that time era still showed significant gains over time. So it's something that, as of the date of our value, that no market participant, willing buyer, willing seller, would have recognized it. We're appraising market value, not distressed value or panic sale value or something of that nature. We're reflecting market value, willing buyer and willing seller.
And so based on that, in your opinion, is it appropriate for the city to continue to rely on the final benefit study as you can confirm in the LID assessments?
Yes.
I'm going to ask you, Bob, to look at the next, the next exhibit, please. Well, actually, C22 we went through yesterday. I don't have any further questions for you on that. So the next exhibit would be C23. Let me know when you've got it.
Yes, I have it.
Okay. For the record, please tell us what exhibit C23 is.
This is a appraisal review of Cirrus finding numerous issues with the special benefit mass appraisal method. So it's an appraisal review by Randall Scott addressed to Frank Humer and Gerald Lutz.
Okay. Are you familiar with this document?
Yes.
Okay. Did you review Mr. Scott's testimony in this hearing?
I believe I listened to his testimony. I've certainly read this review.
What model structure did ABS valuation use for the final benefit study here?
The model structure we used was obviously on a mass appraisal basis, but we used a parcel by parcel analysis where we prepared individual worksheets, looked at comparable sales, depending on the property type. Some we used a cost approach, and whatever applicable method was needed to value a particular property.
So that test, I know you went through this yesterday, but just to summarize it here today, to refresh us, for residential parcels, what approach to value did you use in your analysis?
Direct sales comparison approach.
And for income producing properties like a commercial property, what approach to value did you use?
Typically an income approach, and then we would also look at comparable sales for test of reasonableness.
And then is that the same for hotels?
Yes.
And then for the special purpose properties like the stadium, what approach to value did you use?
Due to the special purpose nature of those properties, we used a cost approach.
How would a reader know the different approaches you used in the study for different types of parcels?
It was well described in our report.
What other steps, in addition to describing it in the report itself, did you take to inform the reader of the approaches you used on a particular parcel?
Individual worksheets were prepared for the commercial properties.
And so if I understood your testimony from yesterday, you did not create individual worksheets for the residential?
Correct. Just due to the vast number of 5,000 or so individual condominium units. The analysis was shown, our conclusions were shown on a spreadsheet. We had sufficient information in the files that needed to prepare reports on the condominium properties as well as the commercial properties. But due to the significant number of condominium units, we just relied on a summation in an Excel spreadsheet rather than doing individual appraisal reports.
I'm going to ask you some, as I walk you through the document, Bob, I'll ask you some questions that involve the acronym USPAP. Can you remind us, what does that stand for?
Yeah, it's the Uniform Standards of Professional Appraisal Practice.
And again, who publishes those uniform standards?
The Appraisal Institute.
And you're a member of the Appraisal Institute?
Yes, I am.
So what is your understanding of Mr. Scott's conclusions in his appraisal review here?
He's saying that I didn't comply with standards 5 and 6.
Standards 5 and 6 of what?
Of USPAP.
So what is USPAP standard 5?
Both standard 5 and 6 deal with mass appraisal. Standard 5 deals with the methodology, and standard 6 deals with the reporting.
I'd like you to turn to page 4 of the exhibit. So that's exhibit C23, page 4. And those are the page numbers, again, Bob, are up at the top. Let me know when you're there.
Yeah.
With respect to USPAP standard 5, what is Mr. Scott's criticism of your final benefit study?
That we didn't set forth a method of appraisal.
Okay, and what is his opinion on model calibration?
That we didn't set up a model to value the properties by.
Okay, I'd like to get exhibit C24 out, please. But I have one further question for you. In exhibit C23, back on page 4, under the heading specification of a property valuation model, what specific standards rule does Mr. Scott claim that you're in violation of?
He says that we're in violation of, we're not employing recognized techniques.
Right, but what rule is that?
The standard 5.4.
So if you could go over to C24, I'm going to walk you through.
I'd like to just point out too that at the bottom of that, comment, it says the models that may be specific using the cost, sales, comparison, or income approaches to value. So we did those types of values. So I don't see how he's saying we don't comply. I mean, it's saying right in the report that they're allowable and allowable under standards 5.4.
Understood. We might wind up saying that again as I walk you through the next document, but I would like you to walk us through standard 5.4, please. So if you could look at exhibit C24, and I'll take you right to page C24, page 4. First of all, before we get there, Bob, what are we looking at in exhibit C24?
Yeah, C24 is the standard 5 mass appraisal development.
And who publishes this?
The Appraisal Institute.
Okay. All right. So again, if you could turn to page 4 of C24.
Yes.
What does rule, and I'm not asking you to, well, let me just walk you through it. Rule 5.4a says, in developing a mass appraisal, an appraiser must, quote, identify appropriate procedures and market information required to perform the appraisal. Yeah, so what did you do to comply with Rule 5.4 here?
Everything it says. We did a parcel by parcel analysis. We did a significant amount of research into the market, into all various elements of the market, supply and demand, sales, income, cost where applicable. So we totally satisfy that requirement.
And how would a reader know that you've satisfied 5.4A?
Read the report. I mean, it's clearly stated in numerous times within the report.
Rule 5.4B again says, quote, in developing a mass appraisal, an appraiser must B, employ recognized techniques for specifying property valuation models. What did you do to comply with Rule 5.4B in your final benefit study?
Again, as I've mentioned, we provided the industry standard approaches that would be applicable to appraising property, the income, direct sales comparison approach, and cost approach again were applicable.
And how would a reader know in looking at your study that you applied those approaches?
Again, looking at individual worksheets or just reading the report.
Rule 5.4C requires, quote, in developing a mass appraisal, an appraiser must C, employ recognized techniques for calibrating mass appraisal models. What did you do to comply with Rule 5.4C here?
Well, we did a parcel by parcel analysis, which is probably more detailed than doing some sort of statistical type of analysis. So we complied in that context.
And what do you understand in his appraisal review, Mr. Scott's critique to be with respect to calibration?
That we didn't do it.
And does he, do you understand why, does he state why he believes you didn't do it?
Because we didn't have a model set up to do it.
And what's your response to that?
We obviously did have a model set up to do it. We're complying not only with USPAP requirements, but we're also complying with state statute requirements. And so we on both ends, they were covered.
You look back,
I have a question.
Bob, at page 5 of C23.
I have a question.
So back to the appraisal review.
Mr. Philippines, question.
Hold on, Bob.
I don't know if your microphone's loud enough to hear me when I'm trying to say something, but you might turn it up. I just wanted to note that in a couple responses to questions, Mr. McCauley's indicated that the response is to read the report. It's a good retort, and I understand that somewhere in the report there's an answer to the question. And the examiner is used to reading through voluminous and challenging documents, whether it's the appraisal here or EISs or what have you. But generally, if you want me to be looking at something specific, it's helpful to bring that to my attention. So if you want to say, look at the report, I'll do my best to look at the report. But if you think there's something specific in there that's responsive to the question being asked, Mr. McCauley, you may want to identify where in the report you're talking about.
Thank you.
You can do it by example if you don't want to list everything.
Thank you. Following up on Hearing Examiner Vansel's comment, can you tell us, Bob, where in, and we can pull back out the exhibit if you would like, but I guess I'll see first if you're able to do it from the top of your head. Can you tell us where in the report you spelled out the different approaches to value that you took to the properties?
I believe it would be under the appraisal methodology.
And is that information, what do the individual property worksheets reveal?
They reveal an income analysis of each property before and after the LID.
Okay. Are there any other spots of the report where a reader would be informed about the approaches to value that you took?
In the context of reading the report, that they would know what techniques we used. And then there's the Excel spreadsheet that summarizes our findings.
Okay, and what's covered, the report that we went through yesterday begins with an executive summary. Does the executive summary address your approaches to value?
Yes.
Also, the report at the very beginning has a cover letter, a 9-page cover letter. How does the cover letter address your approaches to value?
Again, it's covered in there as well.
And how did your formation study, which I recognize is not necessarily at issue here, but how did your formation study address your approaches to value?
Yes, the format of the formation study was similar to our final special benefit study.
Did your approaches to value of the properties, different types of properties, stay the same between formation study and your final benefit study?
Yes, for the most part. The formatting of the analysis was different, but the process was the same.
Ask you to look at the next page of C23. And so I'm taking you to page 5 of C23. Mr. Scott references in the second paragraph on page 5 of C23, USPAP Rule 5.7 entitled Reconciliation or Concerning Reconciliation. What does Rule 5.7 require? And Bob, if you don't know off the top of your head, I will tell you that Rule 5.7 is also contained on page 5 of Exhibit C24. So if that's easier for you to look at page 5 of Exhibit C24, my question to you will be, what does Rule 5.7 require?
That you employ recognized mass appraisal testing procedures and techniques to ensure that the standards of accuracy are maintained.
Okay, well, let me actually take you to page 5 on C24. Please tell me when you're there. Page 5, Exhibit C24,
Yeah, okay.
Bottom of the page.
Okay.
So Rule 0.57a, I'll read it, says, first of all, the rule is entitled Reconciliation. 5.7a, in developing a mass appraisal, an appraiser must reconcile the quality and quantity of data available and analyzed within the approaches used and the applicability and relevance of the approaches, methods, and techniques used. So what did you do to comply with Rule 5.7a in your final benefit study?
Well, again, the relevance of the approaches we used are industry standards. We used methods that are widely acceptable within the industry, and as far as as far as the relevance of approaches, they were all covered there.
And what did you do to confirm the quality and quantity of data available?
Just due to significant amount of research we put into all of the various elements that are outlined in the report, the market data section at the end of the report, the discussion of the various types of properties that are throughout the report, the worksheets that we completed, the discussion we had of our valuation techniques, methodology, conclusions, all of those things reconcile the quality and quantity of the data that we used.
And then Rule 5.7b, again, I'll read it. In developing a mass appraisal, an appraiser must employ recognized mass appraisal testing procedures and techniques to ensure that standards of accuracy are maintained. What did you do to comply with Rule 5.7b in your final benefit study?
Sure. We did a lot of internal review. Again, we're looking at a parcel by parcel basis. So there was a tremendous amount of just internal review to make sure we were maintaining proportionality that was the really main focus of reconciliation and finalizing a report was to do a very thorough internal review to comply with making sure that we tested and made sure that the techniques ensured accuracy.
And I can see, Bob, that it's 10 o'clock, so I'm going to turn my speaker back on in case.
Thank you very much. Yes, we will take a break now and return at 10:15. Thank you. And we return to the record with Mr. McCauley on direct. Before we continue with the city, I do want to briefly come back to the earlier question raised by Mr. Reuters. I realize some of you may be working in your offices today and want an opportunity to take advantage as much time to address how you're going to label exhibits for next week. And for those of you who have questions about this or have concerns about it, how I present, we may proceed this. Please chime in after I give an indication of how I think we may proceed with this. My earlier indication was that certainly reference back to any existing case number and exhibit numbers that we have already established. Many of you presented case exhibits during your case in chief, and you should have a list of the exhibits that you presented during that time, and they were identified and brought into the record. For next week, I had indicated that we would simply pick up with the city's numbering system out of old habit that exhibits would be coming in during the hearing. However, in this case, the examiner has asked that the parties introduce exhibits and share those in advance, and to be possible organize that in advance. I appreciate all your effort to do that. And to help with that, I think a better process that we'll need so that you can identify the exhibit numbers in advance would be to pick up where you left off with your case for your case in chief. So for example, if in your case in chief as an objector, you wound up at exhibit number 32, then you'll pick up with your exhibits that you intend to introduce as part of cross-examination at exhibit 33. So that you can, that way you don't have to wait on each other or coordinate exhibit lists as a group for our submission next week. We can use continue with the city numbering system for any exhibits that are not number organized, and we may do that. But for those of you who are organizing in advance and are attempting to meet the good faith deadline I've set for, I believe it's Monday at noon, to share your exhibits in advance with each other and the city and the hearing examiner's office, I suggest that you continue your case in chief numbering system. And if you need an exhibit list, Mr. Edlin Cho can provide that for your case. It is expected at this point you do have copies of your own exhibits. If you do not, all of those exhibits are available on the hearing examiner website. Again, that's front page of the website. We've listed everything that's in the record for this hearing. And you just scroll down to the bottom and you'll see the exhibits that were presented on any given day or time. Are there any questions or concerns about proceeding in that manner? Does that create any complications for any party? Obviously, we're having to create process as best as possible, but I do want to make sure that this is working as best as we can under the circumstances for each of you.
This is Karen Gillen. I did not participate in the oral hearing, but I did provide exhibits in my appeal. Would those be already included in the exhibits that have been considered and introduced?
If you did not have an oral presentation, but simply submitted in writing an objection with attachments to that, you do not have any exhibit numbers that were identified during the first part of the hearing. So for your case number, then you would be starting with exhibit number 1 under your case number.
Thank you.
Thank you. Ms. Lynn, did you have a question?
Just to be clear, the objectors are not expected to coordinate submission of all of our exhibits together on Monday at noon, but instead, for example, I would just coordinate Perkins' submission of its exhibits on Monday and the hearing. And to the extent we want to introduce exhibits live at the hearing, we will do so via share screen. Is that right?
So yeah, let me go back over that. And I don't want to get too much into everything we're going to do next week. We will do it again at the end of the week. I just wanted to get the numbering system down now in case you're working in your offices and want to start doing that. Correct. I do not expect all of you to coordinate an exhibit list. I appreciate the efforts that the objectors are going to coordinate. That's necessary for real-time use of your time and questions that you'll be asking. But for submission of exhibits, that would take a massive amount of time and effort on your part to do that. And so I think an easier way to do it is for each of you with your respective cases or group of cases, as the case for Perkins Coie, pick up where you left off with your list of exhibits and the number for when you presented your case in chief. And you're not expected to coordinate that with others. It is expected that each of you will, I believe all of the objectors at least, have a full list of emails to communicate with each other that was exchanged during the pre-hearing conference. So I do expect that objectors, you should be prepared on your own behalf to share those exhibits that you had the time to organize and make a good faith effort to organize into a list by that noon Monday date. Share it with everybody. So you got to share it with the other objectors too, so they can follow along when you're asking questions. You certainly have to share it with the city. To the degree that doesn't happen, I recognize everybody's doing what they can. Again, we don't normally involve ourselves in that with the Office of Hearing Examiner. You guys are supposed to share exhibits, but this is an unusual circumstance, so we'll do what we can on the first day of the hearing to pick that up and see where we're at if there needs to be some assistance on our part with the sharing. And also because this is a last minute request, I'm used to doing pre-hearing conferences a month or two in advance, and everybody knows what's coming. So since we are just doing this the best we can, and I recognize that's what you are all doing, I'm not precluding anyone from submitting exhibits that were not submitted by noon on Monday. And so those will be allowed during the hearing. What was asked in my order is that you be prepared if you either have not gotten yourself organized by Monday, and I really encourage you to do that because it will help you with your case and make sure that I understand what you're doing and coordinate us. But if you miss something, or if there's an extra exhibit that comes up, there's two things that I've asked with that. One, I asked that you be ready to email that out during the hearing. So we won't just do share screen. I asked it because people need a copy of the exhibit. And so you need to be ready to have your email list to press send with any new exhibit you're going to introduce during the hearing. And and it will be shared in that manner. If necessary, in those instances, we will also use share screen. And just as you've seen in the past day or so, yesterday, when somebody can't open something, we'll use share screen. So we will use that. I can't rely on it for everything because it does tend to overload our tech system and the recording end of things as well. So I don't want to heavily rely on that for everything. But I recognize it's a tool to help us organize as we go. Does that answer your question, Ms. Lynn?
Yes, thank you.
All right. Any other questions about just the exhibit numbering? We'll get to how we're going to do everything more at the end of the day. But again, recognizing you may be working and trying to organize things now, I wanted to give you that advice on how we proceed with numbering now.
I have a question. This is Mary Moreno. You
Yes.
just said be prepared to email any exhibits to the whole group. Is that only any new exhibits that weren't submitted by the Monday deadline, or not deadline, but request, or anything that we submitted in advance of the cross exam? Do we also need to be prepared to email those out?
So you're going to be, you've listed three different avenues, and thank you for that. So you've got new exhibits that you may have come here. You're going to have exhibits that you're going to be referencing from as part of your questioning. They may be exhibits that you've already identified as part of your case in chief when you originally came in. Those already have exhibit numbers. You may have original documents, new documents that nobody's introduced yet, that you may be part of your documents as well. You're going to introduce. All of those, to the degree possible, should be identified and exchanged by Monday at noon. So everybody's got copies of everything. I recognize that may not happen with all exhibits, and I'm not going to preclude somebody from saying, oh, whoops, I missed number 10. I didn't get a chance to share that. During the hearing, if number 10 is something you still want to share, those are the ones you need to be able to immediately email to everyone during the hearing. Does that make sense?
Yes, it does. Thank you.
All right, any other questions just on the numbering system? Well, again, we'll get to more discussion. I know that we need to make sure that it's tightened up for everyone before next week. But just on the numbering system, does that make sense for now? All right, thank you. We'll return back to the city. Mr. Philippine.
Bob, I was asking you, sorry about me, my speakers, so we don't have an echo. Bob, I was asking you questions about Rule 5.7. Just to conclude those, what do you understand to be Mr. Scott's opinion on your compliance with Rule 5.7?
That I didn't do any testing.
Okay, and what does he base that?
I don't know. Just the fact that I didn't have a model set up and there was nothing to test, I guess.
Okay. And again, so it's clear, what's your response to the argument that you didn't have a model set up?
Well, we clearly had a model. I mean, we did, it's well detailed in the report. We did a parcel by parcel analysis, which is considered a model, and it's clearly defined and discussed in numerous places in the report.
I'd like to introduce Exhibit C25, please. Looking ahead at the break, Bob, I'm actually not going to walk you through this document, but I do want you to identify it for us for the record. What is Exhibit C25?
C25 is Standard 6 mass appraisal reporting.
Okay, and who publishes Standard 6?
The Appraisal Institute.
What does Rule 6 address?
Reporting of your mass appraisal.
And what do you understand Mr. Scott's critique to be of your final benefit study with respect to Rule 6?
Because I didn't have a model, there was nothing to report.
And what did you do to comply with Rule 6?
I've obviously compared a detailed report, did a parcel by parcel analysis, and wrote an extensive report that summarizes our conclusions and data used and the process used in completing our assignment.
Based on your understanding of USPAP as an MAI, do you believe you complied with Rules 5 and 6?
Definitely, yes.
What is the penalty for non-compliance with USPAP?
That would be between me and the Appraisal Institute.
In last question, when you do special benefits analysis, how often has an objector claimed a failure to comply with USPAP standards?
Numerous times. It's a typical line of attack saying that we didn't comply with USPAP.
Okay, and what is the what's your understanding of the leeway that an appraiser has under Standard 5 of USPAP?
Yeah, I mean, there are a lot of different ways, obviously, to do a mass appraisal. You could do statistical modeling and things of that nature. The type of work that we do is specialized, and oftentimes when we're attacked on that realm, the reviewer or the appraiser might not be real familiar with what has to go in and what's required to go in by state law for a special benefit study. But there are a number of different ways to do mass appraisal work, and this is the way we do it. It totally complies with all of the standards. Somebody may choose to do a statistical type of analysis. That's fine. There are a number of ways to do mass appraisal work under USPAP.
I'd like to move on and ask you to look at or grab their Exhibit C26. I'll just give folks, it's a longer document, so I'll just give them a moment at home to pull it up. And before I ask you a substantive question, Bob, while we're waiting for that, can you tell us what is Exhibit C26?
Yeah, C26 is an appraisal review of the Hilton Seattle Hotel by Peter Charette and Jesse Baker with Kidder Matthews.
And are you familiar with this appraisal review?
Yes.
And so I'd like you to go ahead all the way to page 14 of Exhibit C26. And I'll note for you, Bob, and also for the folks at home that we're now in Exhibit 1 of this document. On page 13 at the top, it says Exhibit 1 - Attachment to Appraisal Review. So if anybody, that's relevant for anyone, but in any event, it's page 14 of Exhibit C26. There's a heading that says halfway down the page, difference in before and after condition. In the first line of that, I'll read it into the record, quote, "The study gives the impression that the LID improvements will transform the project to a greater level of improvement than will actually be realized." And my question is, what's your response?
Well, I disagree. I think we went to great lengths to recognize the before condition and that there is a viable waterfront in the before condition. And in my opinion, a significantly improved and better waterfront in the after condition. But I don't feel that we made it something bigger or better than it is.
Is there a requirement that improvements increase property values by a certain percentage in order to justify the use of a local improvement district?
No.
Why not?
The number of LIDs have various components attached to them. Some may benefit property very little, some may benefit property significantly. So there's just often a wide range of value conclusions that are derived from a special benefit study.
Right below that, there's a two-sentence paragraph. Again, I'm on page 14, Bob, under heading 1, difference in before and after condition. Second paragraph there starts with the lid improvements. Mr. Charette notes that connections already exist. And do you agree?
Yes.
Okay. What is how did your study take into account the fact that for some of these areas, connectivity already existed to the waterfront?
It did. I think somewhere in his comment too, he says for years people have found their way to the waterfront. So there are in the before connectivity points. They're vastly improved with the LID, with the advent of the overlook walk, which is going to be a very unique, attractive amenity that provides numerous access points to the waterfront, great view elements, a really unique, stylistic looking structure that I think will provide a lot of amenity to the waterfront area and also provide connectivity. There's also additional connectivity to the Union Street area through an elevator and walkway. So connectivity will be vastly improved.
And you mentioned Overlook Walk and Union Street elevator. What other connectivity improvements will come as a result of the LID improvements?
The Pioneer Square area will have some improved connectivity through the way it'll be designed in connecting to the promenade area.
On the top of page 15 of the exhibit, so next page. I'll read the first full sentence. Quote, "There is no market evidence in the report that waterfront access would change from average to excellent because of the LID improvements." And what's your response?
I disagree. All of the studies we looked at, connectivity is an issue. Obviously, I think the connectivity will be vastly improved. So I disagree with that statement.
The start of the first full paragraph on page 15, right below. Again, I'll read the first sentence into the record. Quote, "There are too many other amenities in the region attracting tourism to suggest that the LID improvements singularly will cause property values to increase." What's your response?
Well, in the before condition, that's the market. In the after condition, we're really isolating the conditions at that time. So based on studies we've looked at throughout the country, there'll be increased, for instance, tourism, market appeal to the area. And so we're looking at those factors in the market in the after condition.
So do I understand that your before condition considers the existing amenities?
Yeah, correct.
And then your after condition adds the LID improvements?
Correct. With the LID improvements, then we're looking at, okay, what are they providing to the market that wasn't there in the before? And one of those elements is an increase in tourism that will result from the project.
The last sentence of that paragraph reads, "It's virtually impossible to identify percentage of value increase from the LID improvements. And to conclude that the LID improvements will substantively change visitor preferences is remote and speculative." And what's your response to that?
I disagree. In all of the studies we've looked at, the implementation of park-like improvements, streetscapes, the elements that the subject waterfront project is completing, the unique elements of the Overlook Walk, aren't speculative. They're well, those types of improvements are well studied and reflected in the market and clearly show market acceptance and increased market value as a result of those improvements.
Also on these on this same page, Bob, there's the second full paragraph. Mr. Charette states that, quote, "There are also consequences from the lit improvements not considered in the report," end quote, such as lost parking and lost street parking and lost views. What is your response to that? And let me split that up. What is your response to street parking?
Yeah, it's something we considered in our analysis.
And how did your analysis consider lost views?
If, for instance, like the Waterfront Landings condominium, there's portions of that condominium that in the before condition will be blocked by a road. And we'd have, the Waterfront Condominium Association is one of the property owner groups we met with. But in the after condition, then the Overlook Walk will block some of their views looking back towards the city. So as much as possible through our analysis of the sales within that complex and other areas, if there weren't applicable sales within the Waterfront Landing, which there were some, where the market participants buying the condos would have been aware of the before condition. They would have been aware of this elevated street that will exist, but they also would have been aware of the Overlook Walk construction since the LID was formed. So those elements would have been reflected in the sales of units within the Waterfront Landings. So that was one way we tried to reflect how the market would look at that type of situation.
And for properties other than Waterfront Landings, did you take into, how did you take into account the potential loss of a view amenity in the after condition?
Just as much as possible based on comparative analysis. If there was a large influx of trees on a main level, that in the same context, there's going to be trees in the before too. So as much as it was applicable in the market, we tried to consider it.
Very next paragraph, Bob, on page 15, so the third full paragraph of Exhibit C26. First sentence reads, quote, "The study also ignores the impacts for development not expected to be completed until 2023/2024. What's your, well, let me read another sentence into the record as well, because I think I could ask you one question on both. Further down, concludes, quote, that the study ignores the uncertainty of completing a 5-year project on time and on budget. So what's your response to the argument in this paragraph?
Again, we had sufficient information provided by the city to detail all of the project elements that are going to be completed by the project, and we're valuing it as of October 1, 2019, assuming those elements are in place. So the expectations of the delayed project and that thing are just not relevant to our analysis.
In addition to the information you got from the city and from the market, what else did you rely upon to reach your value conclusions?
We looked at numerous studies throughout the country that have various elements similar to those being constructed by the LID.
And at the end of the day, how do you pull that all together as an appraiser?
A lot of it's just based on judgment. Looking at the before condition, you're recognizing there's an existing waterfront amenity that exists. And then in the after, looking at numerous different studies of the various elements that go into creating the after situation, and doing an analysis to bring those together and make judgments and apply that judgment to creating your after value conclusions.
And what are you relying on when you make that judgment?
The market evidence that we've collected, not only within the city of Seattle, but in other studies we've looked at.
I'd like to take you to page 27 of the exhibit. C20, exhibit C26, page 27, under the heading, starts at the top of the page, general versus special benefits. And I'm going to direct your attention down to the third paragraph, Bob. The first sentence reads, quote, "The study fails to properly determine that the LID improvements create special benefits to the properties within the LID boundary area." And paragraph goes on to say, because it does not employ a traditional matched pair analysis. My first question for you, Bob, is what is a matched pair analysis?
A matched pair analysis would be looking at you're trying to solve a problem for, say, how much more the market will pay for an additional garage. And so if you have sales of single family houses with one garage and very similar houses with two garages, and that's a defined difference that you can isolate in the market by a matched pair analysis, then that would be an example.
Did you use a matched pair analysis in the study?
We attempted to as much as possible, and looking at other study areas, such as Boston and San Francisco and Vancouver. It's just given the magnitude of the different types of elements that go into the project, it's really not a effective or real reliable method to try to employ.
At the end of this paragraph, again, it's paragraph 3 of page 27 on exhibit C26. The last sentence reads, quote, "The proper measure of benefit is to compare like property transactions with and without the variable that is the project." My first question is, what's your response?
If that data was available, I would agree. Again, given the complexity of a project like this, it's just not possible.
So when you couldn't rely on a matched pair, what did you use to determine whether the improvements would increase property values?
Again, looking at numerous studies throughout the country, the conclusions that were reached in those, which clearly recognize the benefit of open space, park area, parkways, streetscapes, all of the elements that are unique to the subject.
And what role in your analysis did local data play?
Specifically, in the before condition, it provided a very good basis. We had to make adjustments for few elements and recognizing that Alaska Way was rebuilt, but we had very sound evidence to help us both in the before and after, but it really helped significantly in the before condition.
And what role in your analysis did local sales data play?
Similarly, both in the before and after, it played a role and assisted us in our analysis.
You referenced, Bob, in your testimony a number of times, case studies in other cities, as I understand. Why did you choose those case studies?
There were numerous case studies, and often when you're reading a case study, they refer to other case studies. So these were the ones that we felt were most relevant to put in the report and to show the reader and what the outcomes of these studies were. There were numerous other studies that we looked at. When we're writing a report like this, we're trying to keep it summarized, and if we would have included all the studies and explained them and explained our reasoning, we would end up with hundreds and hundreds of pages. So we wanted to pick projects that we thought were most relevant and summarize those, but also internally we recognized there's a lot of other factors we looked at.
And for the case studies that you relied on, how do those case studies reflect the improvements at issue here, or relate to the improvements at issue here?
Well, a lot of the studies, there's a lot of difference of, and we try to be real clear about this in the report, that if you're just trying to take those studies and look at the before conditions vary very significantly between those studies. But to estimate our before condition, we had a lot of good market information available within the Seattle market to really arrive at a good, reasonable conclusions, making adjustments for the hypothetical conditions that existed in the before. Many of these studies go into a lot of detail and a lot of really interesting, consistent data that reflects the strong benefits that are associated with this type of open space, public meeting areas. Then you've got a unique amenity like the Overlook Walk, which is different from any other studies we looked at. It's going to be a really unique attribute in the market. Many of their studies like Boston, Chicago, they also had very unique amenities as well, different but unique. So all those elements were looked at and adjusted for as much as possible using our judgment. And also in the before, recognizing again that we didn't try to overstate that there wasn't a good viable waterfront in the before. And that's a large reason why we didn't have these big increases in value. If you look, like, for instance, at Boston, they show a before and after.
I think you're good, Bob.
Oh, sorry. They show a good before and after depiction, but their before condition was significantly different than our before condition. So, looking at a study like Boston, they reflected a market value difference of about 10 to 15% or so. Looking at that, it was reasonable that we were going to be something less than 10% at an extreme high end of our analysis. It's more likely to be something much less than that, because projects like that, if you just purely took them on the before and after basis, they were much better than what the conditions exist of the subject. So just using our judgment, as we went through and did our analysis, we narrowed down that range of benefit to get to a point where we thought, yeah, this really makes sense to how the market would function in this context through increases in rent, increases in sale prices, and things of that nature. To really, in any appraisal, you try to create a range, and then within that range, say, are we better or worse than this, and narrow it down to a logical, reasonable amount of difference, and that's what we did in this case.
And I think, Bob, that transitions to my next question. In fact, you may have answered it, but let me just ask it anyway and confirm. In the last paragraph on page 27, again, bottom of the page, the second sentence reads, quote, "The changes in the condition before and after were so substantial," and these are the case studies cited in the study and referenced in the HRA reports, quote, "that they dwarf the difference between the condition of the property value before and after the lit improvements and are not credible sources for opinions of value." And what's your response?
Well, as I stated, I mean, I disagree. If you purely looked at them on the before condition, yes, but we had a really good, solid basis for our before value. Again, these studies go into other aspects of it where they look at in the after condition, they look at how the market reacted to these greenways, these open spaces, and streetscapes and park-like amenities and park amenities, and clearly all of them showed an increase in market value as a result of these improvements, and that the investment market, the residential market, all looked favorably upon having these types of improvements in place within their city.
How did you address in your study the impacts from Seattle's sculpture park?
That was a interesting dilemma when we got to looking at the LID boundary areas. When we originally did the feasibility study, we looked at a larger study area, and then as we got into doing the formation study, and we're trying to determine where to draw the boundary lines, we were moving out from where the core elements of the project were. We got to about the Edgewater Hotel, and then when we look beyond that, the property next to that, it's a retail property on the waterfront. You walk out the front of that project and you go right up the steps of Sculpture Park, and we looked at Sculpture Park, and it definitely had a positive influence on the market and the properties around the market as a desirable element for them. And Myrtle Edwards Park is right there too. So Sculpture Park was and Myrtle Edwards Park were kind of elements we looked at. We're trying to compare park amenities to already an existing park amenities. So it was one of the areas that led us to define the boundary where we did.
And I guess just explain for us why did you stop the boundary line there?
Just felt it was a logical distance from the Sculpture Park, where any market influence from that park to where our park elements would stop. When we were just methodically going through a parcel by parcel basis, we got to that point and then it was just one of those judgment calls where are you dealing with measurable special benefit here associated with the waterfront project, or are we dealing with more general benefit? So that's just where we drew the line.
Okay. And in your opinion, again, if I'm understanding it, there was benefit measured from Seattle Sculpture Park, and I believe you said Myrtle Edwards Park.
Yes, we felt there was definitely benefit, positive market elements at play that the market recognized.
And so, what did you do when the benefit you measured, when you couldn't tell the difference between benefit coming from Sculpture Park and Myrtle Edwards Park versus the LID improvements?
And that's where we drew our boundary line.
I'm going to take you to page 32 of the exhibit, please. And again, that's the pages up top.
If we could we go back and talk about boundaries again, just real briefly?
Sure. My next question is on the boundary area.
Okay.
But let me ask my questions, Bob, and we can certainly get at what you want to address, but perhaps it will be covered. If I look at page 32, again, I'm directing you to subheading 3, LID boundary area. First sentence, quote, "There is no justifiable basis or support for the LID boundary areas as they have been determined." And what's your response?
Well, I disagree. I mean, we did an extensive amount of research and analysis that went into our determination of the boundary. And I think it's a fair and reasonable boundary. It's also justified and supported by the management agreement that was reached between the property owners and the city. A significant number of property owners prior to reaching that agreement did receive their preliminary assessment. They knew what the boundary was. They agreed that boundary was reasonable. So there's strong market evidence just right there that the boundaries were supported in the market.
What improvements did you evaluate in determining the LID boundary?
The 6 main improvement elements of the Overlook Walk, the Promenade, Pier 58, Waterfront Park, the Pike Pine Corridor improvements, and the Pike Place Market improvements.
What about Pioneer Square?
excuse me, and the Pioneer Square improvements. Yeah, I think I've said Pike.
In the next sentence, same paragraph, second sentence under subheading 3, page 32. Quote, the primary improvements of the project will be along the waterfront and near Pike Place Market, not away from the water. I'm actually going to continue reading as fast as. LID improvements, as identified by the City of Seattle, extend up the Pine Corridor and from Alaskan Way into Pioneer Square. But these improvements appear to be more of an improvement program to neglected streets, not part of the larger LID project. What's your response?
Well, I disagree. It's clearly stated in the report that these elements, these 6 elements, are looked at as an entity, both before and after. So it's definitely a part of the LID and part of the connectivity and improvements to the overall waterfront area.
When you say it, when you said it's part of the LID, what's it?
Just all of the various elements. The Pioneer Square area, the Pike Pine improvement areas, the promenade, the Overlook Walk, and Pier 58. They're all looked at as one entity, both before and after. So they all contribute and are part of the LID project. We didn't pull apart each element and look at it separately. We're looking at the LID as one entity, both before and after the improvements.
Okay, and why did you make that judgment call to value the LID as the 6 improvements as one improvement?
It was the most logical way to do it than to try to pull each element out as an individual component. It just didn't make any sense. The connectivity issues of all of the various elements flowed together and created one LID. And it was the city's intent to create one LID that had these amenities associated with it. So it was part of my scope of services to look at it as one project.
And then also on page 32, I'll take you down in the last paragraph and ask you, how do you respond to the following claim? First sentence, I'll read into the record, quote, even if one were to accept there are special benefits, they would only accrue to properties closest to the promenade and Overlook Walk.
This is what's really frustrating in reading Charette's review. He provides absolutely no market evidence or anything to support anything he says. And I think he's on record saying, well, there's no benefit to this $346 million waterfront improvement. So is he saying here that now there is benefit, or he's accepting that there is? So I mean, I totally disagree. Again, that the LID is looked at as one entity. So all of the elements is the promenade, the Overlook Walk, the Pike Pine Corridor, the Pioneer Square improvements, and they all create value, and it's not just one of the elements alone that creates value.
In the next, again, the first sentence of the next paragraph reads, quote, it is unreasonable to conclude that properties in the north end of the boundary area will receive any benefit from the LID improvements. What is your position on the properties in the north end of the boundary area?
Well, I disagree. Again, there's no market evidence or support. It's just making a statement based on no evidence. But yeah, we talked to large property owners up there, such as Amazon and Kleiss. Both felt that there would be some benefit, although small, from the waterfront improvements. That area is some distance from the improvements, but the Pike Pine improvements run up to 9th Street or in that area. So we felt that there was an inclusion in there and support and benefit there in the market and that was supported by discussions with large owners like that.
The next sentence reads, quote, "On the south end, neither T-Mobile Park, Mariners, nor Central League Field, Seahawks and Sounders, will ever realize an increase in value from any part of the project, let alone the lit improvements." What's your view on the increase in value to properties on the south end?
Well, I totally disagree with his comment. Anybody that goes to Safeco or T-Mobile Park, for a ball game, if you're playing Toronto or New York or Boston, they're big tourist draws, and I think having a waterfront amenity like this and looking at waterfront amenities in other cities and the tourism they've drawn, the market perception, the improved market perception of the city, of the neighborhoods, all create a positive influence, and that in turn creates a market, an improvement in market value, and that again, that's evidenced by all these studies. So, these stadiums, I think will benefit to some degree. The CenturyLink has a lot of concerts in the summertime. They have the exhibition hall there. They definitely benefit not only from tourism, but the stadium district will benefit by its increased reputation in the market. And again, these are all elements that are consistent throughout the studies.
Will the south end of the boundary zone recognize increased connectivity?
Yes, there's a railroad walk that will extend from just south of King Street that'll take you right into the CenturyLink area field, so it'll have increased connectivity.
And that's part of the LID improvements?
It would be done in the before, but it's looked at in the after. It's benefited by the promenade improvements, and so we considered it an improvement, although it wouldn't be done in the before. It's certainly enhanced by the LID improvements.
If I could take you to jump ahead 2 pages to page 34 of Exhibit C26. There's a header called Inequitable Analysis at the top. And I am going to ask you, Mr. Charette provides, example 1 and example 2 on page 34. And I'm going to ask you questions about those examples, Mr. McCauley. So if you want to take a minute and look at them, make sure you're familiar with them, and then I'll ask my questions.
Yes, I'm familiar. I've looked at this a number of times.
Okay. So let me take you first to example 1. And Mr. Charette points out a difference in value and value increase between the Cyrene Apartments and surface parking. Cyrene at 50 University and surface parking at 1101 Western Avenue. How do you explain the differences between those properties in terms of their valuation?
Yeah, well, in this instance, I think he's just taking one in the service park. I think he's taking just one tax parcel of a larger economic entity. But again, looking at the land values of these properties would be very similar. The land value increase before and after would be very similar. The surface parking area is going to be improved with an apartment complex, and it's part of a larger economic entity. So that $257,000 or $656, I believe that's a low compared to looking at the property as an entity. So again, you're looking at a vacant site that hasn't invested the labor and capital in it to create additional benefit that the Cyrene Apartments would have as they are a functioning, already constructed apartment complex. It's a very similar comparison that I discussed in Mr. Gibbons' report as well.
And please explain for us, how did you determine special benefits for sites that were eligible for development or under development?
Again, just based on highest and best use analysis, looking at land value and whether that land value was less than the capitalized improvement value of the property, or if the capitalized improvement property if it was less than the overall land value, then that would lead to a logical conclusion that the site would have redevelopment potential.
And to close out our discussion of this page, looking at example 2, where Mr. Charette notes that the land square footage is similar between the Amazon office at 1903 Terry, where the land square footage is 42,360, and then the 4 parcels below, where the land square footage is 41,654. Again, my question is, how do you explain the differences between in valuation despite the similar land square footage?
Again, a very similar analogy to what I just indicated. You've got a development site that hasn't invested the labor and capital in it, and so logically, it's not going to have as significant as benefit as a developed site.
On page 35 of the exhibit, next page. Oh, I said on the last one, closing it out, but there is a third example here. Again, Mr. Charette provides 3 parcels that are close in land square footage: 13,160, 14,160, and 13,200. And how do you explain the differences in valuations for those properties?
Similar analogy to what I just described for the last 2 examples.
Now I'll take you to the second full paragraph on page 25. Starts with the word moreover. In fact, I'll just read that sentence. Moreover, there are no latecomer fee provisions in the analysis. What's the relevance of latecomer fees to special benefit analysis in the LID context?
There is none.
And where does, to your knowledge, where does that latecomer fee concept come from?
I don't know. I do not understand his logic or reasoning for even making that statement.
Further down the page, under the header mass appraisal margin of error, so 5, mass appraisal margin of error. First sentence, I'll read it. Quote, the value increase from the LID related improvements opined in the study of 4% or less is within a margin of error for mass appraisals. What's your response?
There is no known margin of error that I've ever heard of, and again, in all the LIDs I've done over the years, we've come across very different differentiations of differences of market value, differences of market value estimates before and after.
Okay, and so to phrase it, my question, or maybe perhaps just to repeat it, what is the industry standard margin of error in mass appraisal?
There is none.
At the bottom of this same page, Bob, there's a section entitled 6, values are overstated. And start of the second paragraph, quote, "There are other examples where the study fails to consider certain deed restrictions or title encumbrances." How did your study consider deed restrictions and title encumbrances?
Yeah, we went to great lengths to try to make sure that we covered any deed restrictions or encumbrances like that. For example, there are 20 or 30 subsidized housing projects in the LID boundary that have a zero benefit due to deed restrictions. There's one property, I think it's the United Way building, where there are air rights that have been sold that we weren't aware of. So that's a property that we just missed. There are some restrictions there that we didn't catch in the market that should be adjusted for. But as much as possible, we tried to catch every property that had deed restrictions or use restrictions that affected the highest and best use of the property, so that it limited their ability to really benefit from the LID improvements.
On page 26 of exhibit, page 36. So next page of exhibit C26. There's a section entitled number 7, economic studies. Are you familiar with this section of the appraisal review?
Yes.
In this section, Mr. Schreck concludes that the study supports a finding of general rather than special benefit. Is that your understanding?
More or less, yes.
What is your response to the arguments in the economic study section?
Well, again, he's talking about the HRNA advisor study. It's an economic study. I mean, that's why we were hired to estimate the real estate market impact. Studies like the HRNA study provide good economic information that helps provide a basis and gives us some information to look at, as well as obviously the other studies we looked at. But we also looked at a variety of studies like the Dr. Crompton study that provided assistance in our work.
I'll take you to, actually going to take you backwards, Bob. So if you recall, that was exhibit 1 to Mr. Charrette's appraisal review. I take you back into the start of the document. First on page 9 of exhibit C26, page 9. And do you see the section entitled on page 9 in the left-hand margin, required revenue increase?
Yes.
Have you read this section?
I've gone over it numerous times, yes.
What do you understand Mr. Charrette to be doing in this section?
The net effect of what he's saying is that there isn't a sufficient enough revenue increase.
And what's your reaction to Mr. Charrette's point here?
Well, one, I've tried to figure out what he's doing here, and I honestly can't discern his logic or reasoning. And there's also a mathematical error here. If you divide the 1,015,000, which is our benefit amount for the Hilton Hotel, if you multiply that by 0.07, I think you come out with like 71,050 rather than 72,450. and that math error regulates all through the numbering system of what he did. I also couldn't figure out where this 41,987 figure came from, but
Where do you see that for the reader?
Yeah, that's just right at the right under the required revenue increase, just after the first paragraph there, where it says value increase 1,015,000.
Okay, and what is so you're referencing where it says 41,987,040 parentheses study implied comma before?
Correct. Yeah, I don't know where that figure comes from. I purely can't figure it out. So he's essentially taking our benefit estimate and then inputting some assumptions that he's made and trying to show that there isn't sufficient revenue created to support the benefit amount.
And what assumptions do you understand Mr. Charette to be relying upon in order to reach his conclusions on the required revenue increase?
He's assuming a daily rate. If that figure changes, his whole calculation changes. There's just a very confusing analysis that I just had a real difficult time understanding and trying to follow.
And does Mr. Charette assume here that what's his assumption with respect to occupancy rate?
Yeah, he's looking at I'm not seeing where that is.
That's fine. Let me take you to the next page, Bob. The required demand increase is text on the left-hand side of the sheet there. Have you read this section of the appraisal review?
Yeah, again, I've looked at it and tried to discern what he's doing here.
Okay, and what's your understanding of the argument?
Yeah, again, that there isn't sufficient demand to support the amount of benefit that we're estimating.
Okay, and what's your opinion of this analysis?
Well, it's just he's twisting and taking our numbers and creating something that reflects that there would need to be 1,800 new units coming online in the marketplace. He appears to be just looking at the before condition and not recognizing any amenities or how the market would buy and sell property in the after condition, or what a willing buyer, willing seller would look at, which is really one of the main determinations of market value and of special benefit. So he's really just appears to be kind of twisting what I've done and inserting assumptions with what he has come up with, and it's really poorly explained. I've just had a real difficult time understanding what he's doing.
Okay. Now I'm gonna, that's all the questions I had for you on C26. So I'll ask you to get out C27, please. What is C27?
This is a supplement to appraisal reviews for the Waterfront Seattle Project Special Benefit Study.
And who's the author?
Peter Charette.
Are you familiar with this document?
I have looked at it, yes.
If you could go to the bottom of page 3 of the exhibit. And let me know when you're there.
Yes.
Under the section on page 3 of Exhibit C27, USPAP Standards Rule 6.1 states that under that section, he quotes from page 44 of your study, and that refers to the case studies you considered. And he has 2 points here. Do you see points numbered 1 and 2?
Yes.
Okay. And I won't read them into the record because they're here. My first question for you is, are those statements in your study?
Yes.
And why did you include those statements in your study's discussion of case studies?
Well, we wanted to be clear and honest with the reader that we're recognizing that there are discrepancies within these studies, especially when you look at them just purely on a before and after basis. Like the Hudson Park study in New York. I mean, if you looked at that purely on a before basis, yes, there's significant differences between our before condition and the before condition there. Again, as I explained, and we tried to explain in the report, to really be fair and honest and purely correctly reflect the market, that we have a operating waterfront in the before condition, and we made estimates of that. So we're letting the reader know if they're looking at these purely on a before, and then assuming that we're comparing that before condition to our subject waterfront area, that there are a lot of dissimilarities there.
At the bottom of right below the 2 points quoted from your report, there's a sentence that, quote, "These statements imply a low level of precision to the estimates in the study." What's your response?
Well, I disagree. I mean, again, he's never called or talked to me to really understand or ask me questions about, what I've done. A lot of these studies provide, when you look at especially the after condition, they provide a lot of similarity to what's going on with the subject property. With the subject project, I'm sorry.
And were you intended to convey here that a low level of precision for the estimates in your study?
No, we're just trying to let the reader know that if you purely look at these projects on a before and after basis, that there's a lot of differences between them and the Waterfront Seattle project.
I'll ask you to look at the next page, Mr. McCauley, page 4 of Exhibit C27. And there's a heading, Case Studies. Do you see that?
Yes.
Okay, and I'll direct you to the last sentence. Mr. Charette states the case studies that you use, quote, "simply fail to provide the necessary support for the increase in value for a nominal change in condition from the LID improvements." And how do you respond?
I disagree. I mean, our research into the waterfront, the Portland waterfront area showed positive market influence due to the project. They also have implemented a very strong management program there that has been very well accepted in the market and has done a lot to enhance and increase market value in that area.
What market data or research does Mr. Charette rely upon for his opinion here?
He refers to a discussion with one of his executive vice presidents that's been there for a number of years.
And do you have access to that discussion?
Only what I've read here.
how would you respond to the argument that the case studies relied on in the study, your study, aren't appropriate because the improvements in those case studies were dramatic, and the improvements in this project are not?
Yeah, again, as I've said, if you looked at them just purely on that basis, they reflect significant market value differences of 10, 15, 20% or better. Our report and our analysis is purely recognizing that that's not reasonable and it's not well supported for what's being done in Seattle market. So our before analysis relies heavily on information that we obtained in the local market through buyers and sellers and rent and income and sales and analysis. So we have a real defined before value, and a lot of these studies have very good after value discussions of the positive elements these projects have provided to these different market areas. For example, in Boston, the Rose Kennedy, the Greenway was completed in around 2007, 2008. Even in 2010, which is during the recession, they were still showing real positive market value increases as a result of this project. So that was after the project was completed. So a lot of these studies have good information relative to that. And that's really what we relied upon and what we tried to make clear. And perhaps we didn't make it clear enough in the report that there are significant differences if you look at them that way. But when you look at their analysis of the after condition, they really consistently define throughout the different cities that you look at that there's a strong market acceptance and desirability affecting the market for projects similar to what's being constructed for the Seattle Waterfront project.
Okay. I'm going to ask you to move to page 12 of Exhibit C27. And at the top, Mr. Charette has a statement on condominiums, and I'll just read the conclusion section. So I'm at conclusion, top of page 12 of Exhibit C27. Quote, there is no empirical evidence to support property value increases for high-end, west-facing residential condominium units from these case studies in the before and after condition assumed in the study. To draw such a conclusion is misleading. And what's your response?
Well, again, I disagree. We looked at a number of studies that had a significant condo population within them. Vancouver, BC is a good example where we looked at the relevance of proximity to parks up there, and the vast majority of that data was related to condominiums. Anybody that's been up in Vancouver, BC, around Stanley Park, Cole Harbor area, there are many real high-end condominiums up there that reflect a lot of desirability from the proximity to those parks. The Boston area has similar types of amenities. So there's good, strong evidence to support that the condominiums, even the high-end condominiums, will benefit from this project.
Also on page 12, right below that, there's a section underlined, the title's underlined, 2019 HRNA Economic Study. And in the final paragraph of that section, Mr. Charette says that the HRNA study involved data that is, quote, not specific to the LID improvements, that the actual impacts of these improvements were not within the scope of the HRNA study. So how did you use what is the HRNA study?
HRNA study is an economic study, and it does consider the elements of the waterfront development.
Okay, and how did you use it?
We used it just mainly to recognize that it's consistent with other projects that we've looked at across the country, that one of the main benefits from creating an entity like this, along with market perception, increased value, is it does increase tourism. And so that was one of the elements that we really focused on in the HRNA study. They had a lot of other economic study and that type of information, but that was one of the main focuses we had. So, the 1.5 million visitors is reflected in this study. They did a 2013 study as well. Excuse me, that reflects about that study reflected about a million net visitors. So, we recognize that's an estimate, but if figures between 1 million and 1.5 million are true, it certainly increases the supply, particularly in the hotel market. It would increase the potential supply that would be needed to meet demand in the hotel market. So it's one of the factors we considered in our analysis. And the HRNA is an economic study. We were hired. That's why we were hired, was to estimate the market value of the real estate difference. They're just purely doing an economic study. So
not a special benefit study.
They're not doing a special benefit study. No, and I don't. So they're looking at the economic impact of the waterfront improvements on the market, not the real estate market value impact of the improvements in the market.
And I'll ask you to look right below that. There's a section headlined Crompton. Did you rely on Dr. Crompton's park studies in your report?
Yes, we used them for good background information. They were informative.
Was that the only resource you relied on in determining the increase in property values from the WIT improvements?
No.
And you probably have told us this, but what other sources did you look at?
We looked at over 25 different studies throughout different market areas relative to streetscapes, bike lanes, open space, park, just a wide variety of different types of elements that are prevalent within the Seattle waterfront area.
Okay, I'll take you to page 13 of Exhibit C27. Looks like it's the second full paragraph. First sentence reads, quote, "From this study, ABS estimates that condominium values will increase by 5% within 3 blocks of the new amenities." And do you agree with that statement?
No, there was no condominium estimate of 5% within the entire study that we did.
What in the study you did, what was the highest increase in value that you saw expressed in percentage terms for a condominium?
Yeah, expressed in the percentage terms was 3% was the highest increase we had for condominiums.
And I have another question for you about this sentence that I read into the record. Were your estimates of condo values based solely on the Crompton study?
No.
How did you use it for estimating condominium values?
Well, it was a good source. Obviously, he's well versed and highly published. So it provided real good background information to show that the market definitely reflects positive, especially in the residential market, reflects positive market value determinations due to park amenities.
Okay.
And again, we didn't look at the whole LID areas like one giant park, but I mean, it provided one of one of the elements in the LID, it provided a good source of background to assist us in our analysis.
Moving on from Mr. Charette, I'm going to ask her, we've heard testimony from John Gordon, also of Kidder Matthews, about ABS's valuation of certain hotel properties in this proceeding. Are you familiar with that testimony?
Yes.
And are you familiar with the restricted appraisals that Mr. Gordon submitted for certain hotel properties in this proceeding?
Yes.
What is a restricted appraisal?
A restricted appraisal report is just a more of an abbreviated report. There are different kind of report classifications, whether you do the summary type report or a limited restricted report, or now use factors basically says it's either an appraisal report, and the scope of the assignment really dictates what you do. But a limited appraisal assignment is really more of an abbreviated report of your conclusions, and then your background information and supporting documentation needs to be retained in your file.
And who is the intended audience of a restricted appraisal?
In this case, it would be the LID, or it should be. the intended user. I mean, if he's going to use it, it should only be used for one client. But I would assume he would be using it for the LID as a client, but perhaps he's not. I don't have the report in front of me.
Okay. For the hotel properties, if you could remind us, what approach or approaches did ABS use to determine the current market value of the hotel properties in the wood boundary?
We used an income approach, primarily an income approach worksheet that has been discussed. And we also looked at comparable sales as test of reasonableness and a good validation of our income approach conclusions.
And what information is used in the income approach when you're valuing a hotel?
You're looking at the potential revenue that the hotel can generate through its room rates, through its banquet, other types of services like that, parking, if there's retail attached to the hotel, to arrive at a gross revenue amount that the property can obtain in the market. Next, operational expense, management expense, any applicable expenses are deducted to arrive at a net operating income.
Okay, how does expected occupancy rate for the hotel figure into the income approach?
Well, it'd be an important element of your analysis.
And how does a capitalization rate figure into an income approach?
Another important element of your analysis. The capitalization rate is the relationship between in a comparable hotel sale or any other office, any other sale, any other commercial sale. It's the relationship between the net operating income and the sale price. So it's very relevant in hotels as other commercial property.
And did ABS, you did your analysis, have the actual operating information from hotel properties?
No, we did not.
Did you ask the hotels for that information?
Just due to the real competitive nature of the hotel market, we knew that it was highly probable that information would be confidential, that there'd be a very low probability of even obtaining any of that. That was to a large degree why we hired Mr. Lukens. He had considerable experience in the hotel market and felt it better to bring on a consultant like that than try to obtain that information independently.
Did the hotels have an opportunity to provide that information to you? And when I say that information, I'm talking about actual operating information.
Yes, I mean, if they had their preliminary assessment study for a significant amount of time, they've at least had a year or better knowing we were doing our final analysis, that if they didn't agree with our preliminary estimate, I would have been more than happy to sit down with them, to talk to them, to look at any relevant information they had pertaining to their hotel, pertaining to their operating income, any issues that they had, not only the hotels but any property owner. So they never reached out to us.
So no hotel provided additional information
No.
after receiving the preliminary benefit estimate?
No.
So without that operating information from the hotels themselves, what did ABS use to determine things like average daily room rate, occupancy rate, expenses? What did you use?
We looked at the best available information. It looked what a typical market participant looking for a room in the market would do. They look at the existing websites like booking.com, hotels.com, Expedia, things of that nature, to try to derive what would be a probable market-based average daily rate.
You mentioned Expedia.com, hotels.com, booking.com. What were your other sources, if any, of market data?
Oh, there were Price Waterhouse, Kidder Matthews, CBRE published reports on the hotel market. We also had Mr. Lukens that did his own research in that. I think he used other sources.
Did you have access to comparable sales data for Seattle hotels?
Yes.
And did you consider that?
Yes.
What was the source of your, or sources of your comparable
Yeah,
sales data?
again, CoStar, which is a highly recognized research entity for compiling sales information and rental information. We looked at CoStar, information from CBRE, and Mr. Lukens provided comparable sales as well.
I believe you testified earlier, but I'll just ask, did you prepare worksheets for the hotel properties?
Yes, we did.
I actually have one here, and I'm going to share this with folks because it's another worksheet, and it's got a lot of data in it, and I don't know what capabilities are at home to read this. So just give me a second here, Bob, and I will share my screen and then ask you some questions. And what this is for you, Bob, and for everyone, is Exhibit C28. It's a one-page spreadsheet. Just give me a second here, Bob. I want to zoom in for folks. Okay. Can you identify this document for us, please?
Yes, this is the Seattle Marriott Waterfront Hotel.
And who created this document?
Primarily Mr. Bird and Mr. Lukens. I had input and worked with them on it, but they were the two main creators of the format.
Okay. Again, I'm going to have you walk us through this worksheet because we've not done one of these for a hotel property. Before I start digging in, though, can you give us a general? I see 3 columns, and please describe what is, not in detail, but what information is contained in the 3 columns.
Yeah, again, this format is similar to the commercial property format that we looked at. So on the far left is the before income analysis, and then there are 2 after value scenarios, the one in the middle and then one on the far right.
Okay, and the income analysis is being applied in both of those scenarios?
That's correct.
Okay, so I'm going to ask you first about the far left column, which you testify was the before column. Blow it up for folks. Come down here. To orient us, Bob, is this section here above the income analysis before? Is that a general description of the property?
Yeah, correct.
Okay, my first question for you is, when I look at the income analysis before, again, far left-hand side, and I'm looking right here for folks. Oh, no, I'm not looking right here. You have an occupancy rate of 80%. Where did you get the 80% occupancy rate?
That's based on market studies that have been done, reliance on Mr. Lukens for his review of the market and what he felt a reasonable market rate, occupancy rate would be, as well as studies that we looked at as well.
Then I see a few rows down here, you've got a room revenue, $315.
Correct.
And where did you get $315 from?
Again, that was based on looking at available sources that we had, Expedia, Booking.com, Hotel.com, sources that any market participant would look at if they're looking to rent a room in the Seattle market.
What is this occupied rooms 104, 536? I see it repeated a few times, but what is that? What is that?
Yeah, that's the number of rooms that would be occupied, less the vacancy rate.
Okay. Occupied in the course of a calendar year? Or
yeah, correct. Yeah, and then that is then multiplied by the average daily rate.
Okay. So then when I scroll down a bit, Bob, am I understanding correctly that you then have a discussion of expenses, or not a discussion, but you provide some data with respect to expenses?
Correct.
And what are the various categories? Walk us through first, actually, Bob. What are your various categories of revenue for the Seattle Marriott Waterfront Hotel in this before column?
Yeah, so we have room revenue, food and beverage revenue, and parking and other income.
Okay. You total those to get a total revenue?
Correct.
Okay, now walk us through the expenses, please.
So there are departmental expenses for rooms, then food and beverage, and parking and other expenses.
Where did you get the information on expenses?
Again, that's market based on published reports that are out there. We had a lot of reliance on Mr. Lukens for his judgment based on his 30 plus years in the hotel market. So a variety of different sources.
Sorry. My next question for you is, my next question for you on the far left side, so I'm in the same column, Bob, come all the way down into the indicated value. It's toward the bottom of this chart. And you have a capitalized at 7.25%. Do you see that?
Yes.
How did you arrive at 7.25% cap rate in the before scenario?
That is looking at what other comparable hotel properties that have sold in the market, what their capitalization rate is in the market. And so it's just a judgment of where we felt the Marriott would fall within the range of capitalization rates that were reflected by various comparable sales in the market area.
Okay, and then you get an indicated value of, very next line, of 167,975,101, $167,975,101. Could you explain for us, how did you arrive at that indicated value?
Yeah, so the capitalization rate is divided. The right above the capitalization rate, you'll see what's called net operating income of $12,178,195. the capitalization rate is divided into that figure to derive the $160,975,000 market value estimate.
And is that a standard approach in the income analysis?
Yes.
All right. I'm now going to ask you to look, and I'd like to just scroll over for folks, but okay, there at this middle column. Let me take you up to the top. Entitled Scenario A, Rate and Vacancy Changes. What's the purpose of this part of the worksheet, Bob?
Similar to our analysis of other commercial properties, we saw in the market that there are really several main driving forces that the market was reflecting that had an influence on market value. And those were change in vacancy and change in revenue or rent. And so in this case, we're looking at the occupancy rate change and potential revenue change.
Revenue from the various sources, hotel rooms, food and beverage, is that correct?
Correct, yes.
All right. And I see here you've got low and high, two columns, low and high. Do you see those?
Yes.
What are you reflecting in those columns?
Yeah, so as far as the occupancy rate goes, we're looking at the low range where there would be no change in occupancy, and then a slight increase in occupancy.
So show that for us in this example. So what do you mean? You said a slight increase. Where does you're looking at something? What are you looking at?
No, I'm sorry. So at the top of the column where we say low, it says 80%. Then it says high, 80.5%.
Okay, so your 80% was your before occupancy rate from the left-hand side of the worksheet, correct?
Correct.
Okay, so you're reflecting here an occupancy rate change of 0.5%?
Correct.
Okay. And then how about with respect to revenues? What are you showing?
Yeah, so revenues were showing a 1.75% increase to 2.2% increase in room revenue.
And why do you have high and low scenarios here? What's the purpose?
Just to try to really reflect the market and bracket how a market participant and a buyer, seller, investor in the market would a tool that they would look at to evaluate their purchasing decisions in trying to acquire an investment like this. So we're just purely trying to reflect how the market's functioning.
And in your opinion, is this bracketed approach you described industry standard in valuing a property like this?
Well, it's more. I mean, it's more specialized to what this type of before and after. The two scenarios are more specialized into how we set up to derive our conclusions of market value. But the methodology, the income analysis is industry standard.
And I should have spoke clear for special benefit studies, industry standard for special benefit studies.
It's our industry standard for doing it. Other people that have done benefit studies may look at it differently. This is the type of approach that we feel is most reflective of the market.
And have you used this approach in other special benefit studies?
Yes.
So what in this column, what information supports the increases in room rates?
Looking at other studies and other market areas that have had influences by similar types of amenities that are provided by the Waterfront Seattle project, and just using our judgment, consulting with Mr. Lukens, felt these types of increases in revenue would be a reasonable reflection of how the market would react based on the location of the Marriott Hotel along Alaska Way waterfront area in the after condition.
And similar question, what information supports your projected increases in room occupancy rates in this scenario A?
Again, market-based, looking at other projects in Boston, New York, other areas, consulting with Mr. Lukens, what we felt a probable change would be in the marketplace.
And when you say market-based, Bob, are you including the Seattle market? Did you or Mr. Lukens analyze the Seattle market as well on these issues?
Yes. We felt there would be some additional demand consistent with all of the other areas we looked at. The same type of market forces would be indicative of the Seattle market as they were in other comparable areas.
And then in scenario, I see we just have a couple minutes before lunch, Bob, but we might be able to get through this scenario A, maybe not, but what about changes in other revenue like food and beverage? How is that addressed in scenario A?
We're keeping the change consistent through both room revenue, food and beverage revenue, and parking revenue. So
why does what does that mean? I guess explain for us. What do you mean you're keeping it consistent?
Well, we're being consistent in the sense that if the market goes up 1.75% for room revenue, we're just recognize the market would look at it kind of consistently throughout the other various revenue sources of the property.
Okay, so for instance, in the low scenario for A, you would have increased food and beverage revenue by 1.75%.
Correct.
Okay,
yes.
Got it.
Yeah.
And then maybe this will be a good last question for you. Why did you do that? Why did you have it consistent?
Just felt it would be consistent with how the market would look at it.
Very good. Thank you, Mr. Filippini.
Mr. Hearing Examiner, this is, I've got noon on my screen. I don't know if you have it as well. This is a,
yes.
I keep going or stop if you'd like.
I was just indicating that we need to conclude. I'm not sure that your mic picks me up very well. But thank you. We've reached the noon hour. We'll return at 1:15. Thank you.